All right, if you're a personal injury attorney, you know this exact feeling. You've battled for your client, you've landed a great settlement, and then that letter shows up, the ERISA lien notice, threatening to just devour a huge chunk of that recovery. It's a pain we all know. But what if I told you there's a strategic playbook to fight back and actually win? Well, in this explainer, that's exactly what we're going to break down. Yeah, this should look way too familiar. A letter from a subrogation giant claiming this unbreakable, ironclad right to get paid back from your client's settlement. You know, for way too long, we've all kind of treated these as these non-negotiable, settlement-killing facts of life. Today, we're going to absolutely dismantle that idea. We're going to show you how to turn this piece of paper into a negotiation and maybe, just maybe, into a complete waiver. So here's our battle plan for today. First, we're going to understand the enemy. Then we dive into 3 distinct phases. Phase 1 is investigation. That's where we build all of our leverage. Phase 2, the legal attack, is where we use their own documents and some major case law against them. And Phase 3, the end game, that's where we execute the win. Finally, we're going to wrap it all up into your new best practice.
Okay, first things first. If you want to defeat an opponent, you have to know who you're up against. And let's be crystal clear about this. The subrogation industry is a massive, well-funded, and formidable opponent. I mean, just look at this. This is not some little back office. This is the Rawlings Group's campus down in Kentucky. They have over 1,000 employees, more than 250,000 square feet of office space, and their one and only job, all day, every day, is to recover money from settlements just like the ones you're handling. They are absolute experts. But here's the secret. Their claims are often not nearly as strong as they want you to believe.
And that brings us right to Phase 1, investigation. Honestly, this is the most critical part of the entire process. This is where you stop just reacting to their demands and you start proactively building the leverage that you're going to use to tear their claim apart.
First up, what the heck is an ERISA plan, right? Well, it's a federal law, the Employee Retirement Income Security Act, that governs most private employee benefit plans. But here is the absolute key. Their super powerful federal right to get paid back only applies if it's a true qualified ERISA plan. Things like government plans, most church plans, they're not covered. So your very first checkpoint is just verifying that this thing is what they say it is.
So how do you verify it? It's a simple 3-step process. Step 1. The second you get that notice, you request the official plan documents and the summary plan description, the SPD. Step 2, you pop over to the Department of Labor's website and look for a Form 5500 filing. And Step 3, you take that paperwork and you analyze it to figure out the plan's funding status. This is the big fork in the road, because if it's self-funded, federal ERISA law takes over. But if it's fully insured, your state's laws, which might be way more client-friendly, are the ones that apply. Now here is where you gain your first real piece of power. The moment you request those plan documents, you're not just asking nicely. You are starting a clock. Under federal law, the plan administrator has exactly 30 days to get you those documents. And this isn't a guideline or a suggestion. It is a hard deadline with very, very serious teeth. And here are those teeth. The law allows for a penalty of up to $110 per day for not complying. And you can see from these cases, the courts are not messing around. In Leicester versus Dovetail, the delay resulted in a jaw-dropping penalty of over $377,000. In another case, Guarini, it was over $160,000. Think about that. By simply sending a letter and marking your calendar, you can create massive, immediate leverage before you even start talking about the lien itself. Okay, so let's move into Phase 2. Once you get those plan documents, or if they're late and you have that penalty hanging over their head, it is time to go on the offensive. Now, you're going to use their own language, or more likely the lack of good language, plus some powerful legal precedent to attack the lien head-on. You've got 2 main legal arguments, 2 equitable doctrines in your arsenal. The first is the made whole doctrine. That basically says the insurance company can't get a single dime back until your client has been fully compensated for all of their damages. The second is the common fund doctrine, which says, hey, since you, the attorney, did all the work to create the settlement fund in the first place, the plan has to chip in and pay its fair share of your fees. And that argument brings us to the absolute landmark Supreme Court case, U.S. Airways versus McCutcheon. This one is a game changer. The court made it unbelievably clear. The common fund doctrine is the default. It's the standard rule. If a plan wants to get out of paying its share of attorney's fees, they can't just say so. They have to write specific, crystal clear language right into the plan documents to get around that rule. So here's the money shot. the most crucial point. You have to attack the plan's language. And any vague wording is your best friend. In the McCutcheon case, the court looked at language that sounded pretty strong. It said the plan had a first claim on the recovery. But the court found that was ambiguous. Does first claim mean the first dollar of the gross settlement? Or does it mean the first dollar of the net settlement after your fees and costs are taken out? That little bit of ambiguity is the crack in the armor that opens the door wide for a common fund reduction. Now for phase 3, the end game. This is where we put all the pieces together. You take the leverage you built from your document request, you combine it with your powerful legal arguments about their flawed plan language, and you negotiate from a position of serious strength. You're not asking for a discount anymore. You're aiming for a major reduction or even a total walkaway. Let's look at how this plays out in the real world. Check out this timeline. June 18th, the attorney sends the initial request for documents. Just 11 days later, on the 29th, he follows up with a detailed email pointing out all the legal problems with their plan language, citing McCutcheon. Now, watch what happens next. On July 6th, the recovery agent asks to get on the phone. That's a classic move, right? They want to avoid a paper trail. The attorney smartly insists on keeping it in writing. Less than 2 weeks later, total victory. And here it is, the proof. This is the actual email from the FIA group, and I quote, "Due to our lack of applicable ERISA language within the plan document, we will not be pursuing reimbursement for your client." Boom, a full 100% waiver. This is tangible proof that when you execute this playbook, it works. They knew their plan language was weak, they knew it wouldn't survive a legal fight, so they folded completely. But okay, what if they don't fold? What if the negotiations just stall and they try to hold your client's settlement hostage indefinitely? Well, that's when you pull out the Montanile tactic. This is another Supreme Court case that gives you a massive tool. You send them a written notice saying you intend to disperse the disputed funds to your client. You give them a reasonable deadline, say 14 days, to either file a lawsuit or formally object. If they do nothing, the court has said they can't come back later and try to sue your client to get at their general assets. You force them to put up or shut up. So let's wrap all this up and talk about your new standard of practice. This isn't just a handful of neat tricks. This is a fundamental shift in how you should be approaching every single ERISA lien claim that crosses your desk. This whole strategy can be boiled down to this one powerful phrase: cooperate, don't capitulate. Yeah, be professional, you cooperate, you follow the steps, but you never, ever just roll over and accept their opening demand at face value. You always investigate, you always challenge the language, and you always, always negotiate from a position of strength. And that really just leaves us with one final and I think pretty important question. Think about every time you've paid one of these liens without putting up a fight, without demanding the plan documents, without putting that language under a microscope. Were you leaving your client's money on the table? By making this playbook your new standard practice, you can make damn sure the answer to that question is no, and you can maximize the recovery that your clients fought so hard for and truly deserve.